Ever feel like the law is, all straight lines and sharp corners, like a really precise structure?
Hmm. Very rigid sometimes.
Exactly, but then you stumble across equity and it's different. It's like finding this sort of hidden garden inside that structure.
Right. Where there's a bit more flexibility, maybe a
Right.
focus on fairness.
Yes,
Wow.
precisely, where the strict rules might cause problems. So, okay, let's dig into a specific area where this tension really plays out.
Okay.
We're doing a deep dive today looking at question Nobin 1 from the University of London LLB program's 2021 June exam. It's the Equity and Trusts paper.
Ah, yes. A classic area.
And the question goes like this. Sections 5E3, 1B, and C of the Law of Property Act 1925 each create a strong rule because written evidence is the only reliable indication of whether a trust or equitable interest has been created and in whom, at any given moment, that trust or interest resides. Then it asks us to critically discuss, with reference to case law.
A very direct statement to grapple with.
It is. And just to mention, this answer is brought to you by Sonorbit Academy Sri Lanka. So our mission here is to really, unpack that statement. We need to look at the actual law, sections 53, 1B, and C of the Law of Property Act 1925.
The core provisions.
And then see how the cases have, well, sometimes supported, but sometimes found ways around this idea that writing is the only reliable signpost.
Finding that balance.
Exactly. It's about that balance between legal formality, the rules, and achieving a just result. Fairness.
Well, it's a great question because it starts with that strong claim. Is written evidence really the only reliable indicator? I mean, the 1925 Act definitely lays down some pretty firm rules here.
It seems to.
You've got Section 531B, which is all about declaring trusts over land or any interest in land.
Okay.
And it says these need to be manifested and proved by some writing, crucially signed by the person declaring the trust.
Right. Signed writing for land trusts.
And then there's Section 531C.
Yeah.
This one deals with disposing of an existing equitable interest or trust.
So transferring the benefit.
Exactly. And that has to be in writing, signed by the person disposing of the same or by their agent.
Also in writing. So it seems like Parliament really wanted things documented, black and white.
It certainly looks that way. The emphasis is clearly there.
Okay, so on the face of it, pretty straightforward. Land trusts, transferring equitable interests, get it in writing. And the question suggests there's a good reason for this strong rule.
Absolutely. And if you think about why, the reasoning, which cases like Gray v. IRC touch upon, it really boils down to a few key things, primarily preventing fraud,
Right. That makes sense.
especially with something like land, which is valuable.
Yeah.
Without writing, you could imagine all sorts of bogus claims about trusts popping up. It would be chaos.
Total uncertainty.
Exactly. Which leads to the second point,
Mm-hmm.
certainty. Written agreements, signed documents, they minimize misunderstandings down the line. You know where you stand.
Provides clarity.
And third, it's about evidence. A signed document is concrete proof. It shows the trust exists or the interest was transferred. It's that clear trail.
Okay, yeah. Shield against fraud, basis for certainty, clear evidence. Makes perfect sense why you'd want a written rule. And the courts seem to back this up quite strongly, don't they? The question asks about case law.
Yes, several key cases really hammer home this principle.
Let's start with Gray v. IRC. You mentioned it. What's the key takeaway there regarding this rule?
Gray is a really good example of the courts taking Section 531C very seriously. What happened was oral instructions were given to trustees about shares.
Okay, just told them what to do.
Essentially, yes, to hold the shares under new trusts. But the House of Lords said, no, that doesn't work. That oral instruction was actually a disposition of the existing equitable interest.
Ah, so it triggered 53(1)(c).
Precisely. And because it wasn't in writing, signed, it was ineffective. It really shows the court prioritizing that statutory requirement for writing when beneficial ownership moves.
So even though the intention might have been clear verbally, the lack of writing meant it failed legally, especially for tax purposes, I imagine.
That was certainly a major factor in Gray. Then you have Oughtred v. IRC. How does that fit in?
Another tax case, wasn't it?
Yes, often these things surface because of tax implications. In Oughtred, there was an oral agreement to swap some shares. An agreement between mother and son, I think.
Okay, a clear agreement.
Seems like it. But the court, again, held that the oral agreement itself wasn't enough to actually transfer the equitable interest.
Why not?
Because the transfer, the actual disposition, still needed to comply with the writing requirement of 531C. The later written transfer document was the key thing.
So the intention, even if agreed orally, didn't complete the transfer legally without the writing.
That's the gist. The formal act of disposition needed that formality. Intention alone wasn't sufficient for the property to move in equity, not without writing.
It's like, saying you'll sell your car is different from actually signing over the registration document.
A good analogy. The legal step needs the formal process.
And the risks of getting this wrong. Well, Vanderbilt v. IRC really brings that home, doesn't it? Real-world pain.
Oh, absolutely. Vanderbilt is a cautionary tale. Mr. Vanderbilt wanted to gift shares to the Royal College of Surgeons, avoid tax. It got complicated.
How so?
Well, the shares were transferred, but there was an option for a trust company, Vanderbilt Trustees Ltd., to buy them back. The issue was, who did the trustees hold that option and later the shares for?
The documentation wasn't clear.
Exactly. The documentation about who the shares were ultimately held in trust for after being bought back wasn't properly sorted out. This lack of clarity, the absence of a clear written declaration for the resulting trust of the option, led to huge tax problems for Vanderbilt himself.
Because the beneficial interest wasn't clearly disposed of in writing.
Precisely. It bounced back to him via a resulting trust, basically. It shows the very real, very expensive risks if you don't nail down the written evidence, not just theory.
Okay, so Gray, Oughtred, Vanderbilt. They all point towards this strong rule. Writing seems essential, significant consequences if you ignore it.
They definitely build a strong case for the importance of the statutory requirement.
But, and there's always a but with equity, isn't there?
Suckles, often, yes.
We said equity steps in to prevent unfairness. So does that mean written evidence isn't always the only reliable sign? Are there exceptions?
Exactly. This is where it gets more interesting, more nuanced. Equity has long recognized that rigidly sticking to the need for writing can sometimes, ironically, facilitate fraud or create injustice.
Right. Using the rule unfairly.
Yes. And the Act itself acknowledges this. Section 532, the Law of Property Act, is crucial here.
What does that say?
It basically carves out an exception. It says that the rules in 53(1)(b) and (c), the writing requirements, do not affect the creation or operation of resulting, implied, or constructive trusts.
So certain types of trusts are exempt from the writing rule.
Correct. And this is where equity's flexibility really shines.
Okay, let's take constructive trusts first. They seem like a major way equity gets around the writing requirement. Rochefoucauld v. Bousted comes to mind.
Rochefoucauld is the absolute classic here, foundational. What happened was land was transferred to the defendant, Bousted.
Okay.
But there was an oral understanding, an agreement, that he'd hold it on trust for the claimant, Rochefoucauld.
But nothing in writing about the trust.
Nothing. So later, the defendant tried to rely on the statute, what's now 53(1)(b), saying, look, no writing, so no enforceable trust, the land is mine.
Cheeky.
Very. But the Court of Appeal famously said no. They stated the principle. The statute was designed to prevent fraud, not be used as an instrument of fraud.
So they wouldn't let him use the lack of writing to cheat the claimant.
Exactly. Equity stepped in and imposed a constructive trust based on the oral agreement to prevent that unconscionable behavior. It shows equity overriding the need for writing to stop fraud. Substance over form.
That makes total sense. The purpose of the law shouldn't be twisted like that. What about resulting trusts? You mentioned they're also exempt under 533. How do they arise without writing?
Resulting trusts typically arise automatically in certain situations, often linked to contributions to the purchase price of property.
Like if I pay for half a house, but it's put in your name only.
Exactly. In that scenario, unless there's evidence of a gift or loan, equity presumes you hold your legal title partly on a resulting trust for me, reflecting my contribution. No written declaration is needed for that presumption to arise.
Okay. Is there a key case for that?
Hodson v. Marks is a good illustration. An elderly lady transferred her house to her lodger
Why?
based on an oral agreement that she would remain the beneficial owner, that he was just holding it on trust for her. No writing. He then sold it.
Oh, dear.
But the court found a resulting trust existed in her favor because of that initial understanding, despite the lack of writing. Her beneficial interest survived the sale to Marks, who wasn't a bona fide purchaser for value without notice. It shows the trust arising from the circumstances, not the writing.
So, again, equity looked past the lack of formality to the underlying reality.
Yes, based on the presumed intention inferred from the circumstances of the transfer.
And it's not just these formal trust categories, is it? Sometimes can't trusts arise from more informal situations, like words and actions?
Yes, absolutely. Equity can sometimes infer a trust from conduct and informal words. Paul v. Constance is the go-to example here.
What happened in that one?
It involved a couple, Mr. Constance and Mrs. Paul. They weren't married. He received some damages, put it in a bank account in his name only,
Okay.
but he repeatedly said to her things like, "The money is as much yours as mine." They also used the account together, paid joint bingo winnings into it.
So they treated it like a joint pot.
Pretty much.
Mm.
When he died, his estranged wife claimed the money as his sole property. But the court looked at his words as much yours as mine and their conduct.
And what did they decide?
They decided that, even without any formal declaration, his words and actions were enough to show an intention to create a trust of the money in the account for both of them.
Wow. So very informal words were enough.
In that context, yes. It
Yeah.
shows equity looking at the substance, the real intentions expressed through everyday words and behavior, not just searching for a formal document.
Okay, so let's pull this together. We started with the idea from the Act, sections 531B and C, setting this strong rule needing written evidence,
Right, for land trusts and dispositions of equitable interests.
driven by preventing fraud, ensuring certainty, providing evidence, and cases like Gray, Oughtred, Vandervelde really back that up, showing the risks of not complying.
They certainly do. They uphold the statutory formalities.
But then equity comes along with Section 532 and these exceptions. Constructive trusts in Rochefoucauld to stop fraud.
Mhm.
Resulting trusts, like in Hodgson v. Marks, arising from contributions or circumstances.
Yes.
And even informal declarations, like as much yours as mine in Paul v. Constant.
Exactly. All situations where trusts or interests are recognized without the formal writing required by 531.
So this clearly shows that written evidence isn't the only reliable indicator, despite what the question initially suggests.
It demonstrates that equity can, and does, look beyond the writing requirement in specific circumstances to achieve justice.
Equity wants fairness. Sometimes they pull in different directions.
That's the absolute core of the critical discussion here. Rochefoucauld is a prime example.
Hmm.
Preventing unconscionable conduct trumps the writing requirement. But you have to acknowledge that this flexibility, while essential for justice, does potentially chip away at that legal certainty the statute aimed for. If the rules can be bypassed, does that make things less predictable?
It's a balancing act.
Always a balancing act in equity. Upholding the statute's purpose versus ensuring fairness on the facts.
And this isn't just old law, right? People still debate if these rules work perfectly today.
Oh, yes. There's ongoing discussion. Law commission consultations sometimes look at whether these formalities, designed long ago, are still perfectly suited for, say, modern commercial transactions. Are they hindering things? Do they strike the right balance now?
It's a living area of law.
Definitely.
So wrapping up this deep dive then, the statement in the question that writing is the only reliable indication, well, it's too strong, isn't it?
It's an overstatement, yes.
While sections 531B and C are vital safeguards, frequently upheld, equity's exceptions constructive, resulting, sometimes informal trusts clearly show interest can arise without writing.
They absolutely can. The case law proves it.
So it's this constant interplay. Statute provides the framework, the general rule for certainty. Equity provides the necessary flexibility to ensure fairness.
That's a perfect summary of the tension.
Yeah.
Legal certainty versus equitable fairness.
Okay, so here's a final thought for you, the listener, to mull over. Thinking about this balance.
Yeah.
In what kinds of situations do you think sticking rigidly to the need for written proof is most crucial? Where is certainty paramount?
Good question.
And on the other hand, when is that flexibility of equity, the ability to look beyond the paperwork most necessary to make sure the outcome is actually just? Where does fairness have to win out?
Worth pondering. It gets you thinking about the fundamental values at play in our legal system.